The single most important legislative instrument relating to international commercial arbitration is the New York Convention, the United Nations Convention of 1958 on the recognition and enforcement of foreign arbitral awards, also termed the New York Convention because it was negotiated and signed in New York in the United States in 1958. The convention plays a vitally important role in the international arbitral process. The New York Convention was adopted at the behest of the international business community in order to address the particular risks and uncertainties arising from cross-border trade and investment. The convention was designed in particular to improve upon the legal regime for international arbitration under the 1923 Geneva Protocol and the 1927 Geneva Convention. The New York Convention, as it was ultimately drafted and adopted, is a global constitutional charter for international commercial arbitration. It adopted and it provides a radically innovative regime for international commercial arbitration that combines provisions dealing with both international arbitration agreements on the one hand and international arbitral awards on the other hand into a single legislative instrument. The New York Convention's terms are expansive. They provide a robust pro-enforcement framework for the recognition and enforcement of both international arbitration agreements and arbitral awards. They provide means for ensuring that international arbitration agreements are enforced in accordance with their terms and that arbitral awards are recognized and enforced in contracting jurisdictions around the world. Initially, the New York Convention attracted only a few ratifications. The convention was negotiated in the summer of 1958, as we've said, in New York. Only 26 of the 45 states that participated in the final drafting session of the convention signed the convention before it entered into force in June 1959. A number of major trading states did not ratify the New York Convention for some years following its entry into force. The United States, for example, did not ratify the convention until 1970. Other states were also slow to adopt the convention. Nonetheless, over time, the convention became essentially universal, essentially global in its coverage. We can see the coverage of the convention, its essentially universal coverage, on the map on this slide. Despite its importance, the New York Convention is a short document. It's only a few pages long, and its most important provisions take up only 7 articles. The convention is set forth in 5 languages, all equally authentic: English, French, Spanish, Russian, and Chinese. The convention does not purport to provide a comprehensive legislative regime for international commercial arbitration. Instead, it deals primarily with international arbitration agreements in Article 2 and international arbitral awards in Articles 3, 4, and 5. It does not contain provisions regulating comprehensively the arbitral procedure, the part of the arbitration between recognition of international arbitration agreements at the beginning of the arbitral process and recognition of arbitral awards at the end of the process. Instead, the convention is directed to agreements on the one hand and arbitral awards on the other hand. The convention provides uniform, mandatory international rules. Those rules govern, as we've seen, both arbitral awards and arbitration agreements. The provisions governing arbitral awards are contained in Articles 3, 4, and 5. Those provisions require contracting states, in Article 3, to recognize arbitral awards as binding and to enforce them in accordance with the procedural rules of the recognition forum. Article 4 sets forth a simplified procedure for proving the existence of arbitral awards, ensuring that award creditors, parties holding awards in their favor, are able to prove the existence of an arbitral award simply and expeditiously. An arbitral award may be denied recognition by a contracting state only in very limited circumstances. Those circumstances are set out exhaustively in Article 5 of the New York Convention. We can see the provisions of Article 5 of the Convention on the current slide. Those provisions do not permit national courts to review the substance of the arbitrator's decision, the merits of the arbitrator's resolution of the parties' disputes. Instead, Article 5 is limited to non-recognition of awards where there was an excessive jurisdiction, either because there was no valid arbitration agreement or because the arbitrators exceeded the scope of the arbitration agreement. Non-recognition is also permitted where there have been serious procedural irregularities, either denying the parties an opportunity to be heard or alternatively not conducting the arbitration in accordance with the parties' agreed arbitral procedures. Finally, arbitral awards can be denied recognition on the limited basis of public policy or non-arbitrability rules. Other than these bases for non-recognition, however, arbitral awards must be recognized as a mandatory matter of binding international law. Article 1 of the Convention provides that the Convention applies to foreign arbitral awards, awards made outside the jurisdiction in which they are recognized. The Convention requires an award made in State A to be recognized in other states, States B, C, and D. The Convention does not address the recognition of an award made in State A itself. In that jurisdiction, State A, the award is a domestic award, not a foreign award, and thus not subject to the Convention's terms. Article 1 also permits states to treat certain awards as non-domestic, even if they are not foreign. Although that is not the principal focus of the Convention, a few states have taken advantage of this provision and extended the scope of the Convention. The Convention's primary focus, however, is on foreign arbitral awards, consistent with the Convention's focus on international commercial arbitration. The title of the New York Convention is the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards. The title does not refer to international arbitration agreements. Nonetheless, the Convention includes important provisions regarding the recognition and enforcement of international arbitration agreements. Those provisions are found in Article 2 of the New York Convention. Article 2, subparagraph 1 of the New York Convention requires each contracting state to recognize an agreement in writing under which the parties undertake to submit to arbitration all or any differences which have arisen or which may arise between them. This provision, derived from the 1923 Geneva Protocol, requires as a mandatory rule of uniform international law that all contracting states recognize international arbitration agreements, recognize the material terms of international arbitration agreements. Article 2 also requires, in Article 2, subparagraph 3, that national courts specifically enforce international arbitration agreements by referring the parties to a dispute subject to arbitration. National courts are not permitted to retain the dispute and resolve it themselves. Instead, Article 2, subparagraph 3 requires that the court of a contracting state, when seized of an action in a matter in respect of which the parties have made an agreement within the meaning of this article, shall, at the request of one of the parties, refer the parties to arbitration, a binding, mandatory international law requirement that parties to valid arbitration agreements be referred to arbitration for resolution of their disputes. Article 2, subparagraph 3 includes an exception in cases where a national court finds that the said agreement, the arbitration agreement, is null and void, inoperative, or incapable of being performed. Article 2 contains a limited set of exceptions to the general obligation to recognize and enforce international arbitration agreements. This parallels the approach of Articles 3, 4, and 5 of the New York Convention, a presumptive rule of validity of arbitral awards in Article 3, paralleling the presumptive rule of validity of arbitration agreements in Article 2. In each case, with exceptions for the recognition of arbitral awards in Article 5, exceptions for the recognition of arbitration agreements in Article 2, subparagraph 3, a basic international rule subject to a limited number of exceptions, exclusively and exhaustively defined in the text of the Convention. Article 7 of the Convention then goes on to address a basic aspect of the architecture of the New York Convention. Article 7, subparagraph 1, provides that the Convention, nothing in the New York Convention, affects a party's rights under an arbitral award as enforced under either national law or any other international agreement. Article 7, subparagraph 1, provides that the Convention shall not deprive any interested party of any right he or she may have to avail himself or herself of an arbitral award in the manner and to the extent allowed by the law or the treaties of the country where such award is sought to be relied upon. Article 7 of the Convention makes the Convention operate as an international floor for arbitration agreements and arbitral awards, not an international ceiling. Put differently, the Convention requires states, contracting states, to recognize arbitral awards in specified circumstances. It permits them to deny recognition of arbitral awards in other circumstances, but nothing in the Convention requires states to deny recognition of arbitral awards. States may rely on both their own domestic law or other international treaties to recognize arbitral awards, even when the New York Convention would permit them to deny recognition. The Convention guarantees the recognition of arbitral awards. It never forbids or prohibits the recognition of arbitral awards. The same analysis is applicable by analogy to international arbitration agreements. Although Article 7 is phrased in terms of arbitral awards, like the title to the New York Convention, its architecture applies equally by analogy to international arbitration agreements. The New York Convention accomplished its drafters' objectives in most respects. Importantly, the Convention improved substantially upon the legal framework for international arbitration which had been established by the Geneva Protocol and the Geneva Convention. The New York Convention shifted the burden of proving the invalidity of arbitral awards to the party resisting enforcement of the award. That is made explicit in Articles 3, 4, and 5 of the New York Convention. Articles 3 and 4 provide for the award creditor to prove the existence of an arbitral award by producing copies of the award and virtually nothing else. In contrast, Article 5 of the Convention places the burden of proving that one of the exceptions to the obligation to recognize arbitral awards is on the award debtor, the party resisting recognition and enforcement. The New York Convention also abolished the previous so-called double exequatur requirement under the Geneva Convention. That requirement mandated that the award creditor, after receiving a favorable award in the arbitral seat from the arbitral tribunal, confirm the award there in the courts of the arbitral seat before it took the award to other jurisdictions to seek recognition and enforcement. This meant, for example, that if the arbitral seat was in State A, before the award creditor could take the award to States B or C to have it recognized or enforced, it needed to have the award confirmed in State A. Only after the first exequatur was the award creditor able to take the award to another jurisdiction, States B or C, for a second exequatur, recognition, enforcement, and ultimately execution. This process was inevitably slow, cumbersome, and expensive. It defeated some of the basic objectives of the international arbitral process. The New York Convention specifically abandoned any double exequatur requirement. An arbitral award may be taken from the arbitral seat, State A, under the New York Convention and immediately recognized and enforced in other jurisdictions without any requirement for exequatur or confirmation in the arbitral seat. The New York Convention also combined the subject matters of the Geneva Protocol and the Geneva Convention, international arbitration agreements on the one hand, international arbitral awards on the other hand, into a single instrument, providing a comprehensive regulatory regime for both international arbitration agreements and international arbitral awards. The Convention also indirectly addresses the middle part of the arbitration, not the beginning of the arbitral process, recognition of arbitration agreements, or the end of the arbitral process, recognition of arbitral awards, but the middle of the arbitral process, the arbitral proceedings themselves. The Convention does so in two ways, both indirectly. The Convention addresses the arbitral procedures because it requires contracting states to recognize all the material terms of international arbitration agreements. It does so, as we've seen in Article 2, subparagraph 1, requiring that contracting states recognize international arbitration agreements. That includes recognizing all the procedural terms in those agreements that the parties have agreed upon. Equally, Article 5 of the New York Convention, dealing with recognition of arbitral awards, also recognizes the central importance of the parties' procedural autonomy. It does so in Article 5.1d, which permits non-recognition of arbitral awards where the arbitral procedure was not in accordance with the parties' agreement. Again, placing central importance on the parties' procedural autonomy and thus indirectly regulating the middle part of the arbitration, the arbitral proceedings themselves. The New York Convention provides a truly global constitution for international commercial arbitration. It provides mandatory rules of international law binding on 160 states around the world. In interpreting the New York Convention, those contracting states have looked both to the Convention's terms, but also to the decisions of other contracting parties to the Convention. We can see examples of this approach towards interpretation of the Convention on the current slide. The English Court of Appeal, followed by the House of Lords in the Fiona Trust versus Privalov decision, cited both German and U.S. authorities in interpreting the New York Convention and applying it in English courts. U.S. courts have done the same, citing English, Hong Kong, Swedish, and Swiss authorities in interpreting the Convention. Other courts, the Indian Supreme Court, has cited Swiss, English, and other authorities, as well as the legislative history of the UNCITRAL model law on international commercial arbitration in interpreting the New York Convention. All of these various national court authorities, as well as countless others, have looked to international commentary on international commercial arbitration as well, developing a kind of international common law of international arbitration. The New York Convention provides the foundation for that common law, for the law of international commercial arbitration. It provides a global constitution for the international arbitral process. The New York Convention has been exceptionally successful. It's been termed the most successful private international law agreement in existence today. In the words of the former president of the International Court of Justice, Steve Schwabel, it works. The convention works. Slightly less concisely, another commentator remarked that the convention is the mortar of the edifice of international commercial arbitration. And in the words of yet another commentator, despite the convention's brevity and focus on arbitration agreements and arbitral awards, the significance of its terms can scarcely be exaggerated. The convention established for the first time a comprehensive international legal framework for international arbitration agreements, arbitral proceedings, and arbitral awards. Let's briefly consider some of the other principal international arbitration treaties or conventions in force today. The Inter-American Convention on International Commercial Arbitration was negotiated in the 1970s between the United States and a number of South American states. Those states had historically been suspicious of the international arbitral process. The Inter-American Convention, also termed the Panama Convention, was envisaged as a stepping stone from that reluctance ultimately to the New York Convention. The Panama Convention was meant to provide terms similar to the New York Convention that over time would lead South American states to accede to the New York Convention. Most importantly, like the New York Convention, the Panama Convention provided for the presumptive validity and enforceability of both international arbitration agreements on the one hand and arbitral awards on the other hand. The terms of the Inter-American Convention closely paralleled those of the New York Convention. We can see in Article 1 the obligation to recognize and enforce arbitration agreements, and in Article 5 the obligation to recognize and enforce arbitral awards, paralleling Articles 2 and 3, 4, and 5 of the New York Convention. In addition, the Inter-American Convention introduced an important procedural innovation. That innovation was contained in Article 3 of the Convention. It provided, and we can quote from the slide, "In the absence of an express agreement between the parties, the arbitration shall be conducted in accordance with the rules of procedure of the Inter-American Commercial Arbitration Commission." The Convention provided for the establishment of the Inter-American Commercial Arbitration Commission, an arbitral institution. That institution, in turn, promulgated institutional arbitration rules, modeled very closely on the UNCITRAL arbitration rules. Critically, Article 3 established a default rule. Parties were free to agree to conduct their arbitrations either as ad hoc arbitrations or according to any set of institutional arbitration rules that they wished. If they did so, Article 1 of the Convention required giving effect to that agreement. Absent agreement, however, Article 3 of the Inter-American Convention provided that the arbitration would be conducted pursuant to the Inter-American Commercial Arbitration Commission's arbitration rules, pursuant to a default set of institutional arbitration rules. This was an important procedural innovation not contained in the New York Convention. Other provisions of the Convention, Article 2 in particular, addressed the constitution of the arbitral tribunal. Again, it did so more directly than the New York Convention did, representing in some ways an advance upon the provisions of the Convention. Also, the Convention, the Inter-American Convention, contained no express equivalent to Article 2, subparagraph 3 of the New York Convention, which required courts of contracting states to refer parties to arbitration. That obligation, nonetheless, is implicit in the requirements imposed by Article 1 of the Inter-American Convention. The Inter-American Convention has some 24 contracting states today. Most of those contracting states have now also acceded to the New York Convention. As a consequence, the practical importance of the Inter-American Convention has reduced significantly. It nonetheless played an important role in the development of international arbitration, and its procedural innovations remain positive contributions to the international arbitral process.